can't be eating video. Okay, we should be recording.
Okay, my name is Alex Geiger. Welcome to today's edition of Lunch and Legal. Today's topic is a review of recent Supreme Court decisions with a Jewish slant. And when I say recent, we're going to talk about the cases decided yesterday. And I wish they had decided a couple more. We would have spoken about those as well, but there will be more decisions tomorrow. Not today. Okay. So, first of all, you all have in front of you this picture. As you may or may not know, the Supreme Court does not allow cameras in the courtroom. So this is a artist sketch of what the Supreme Court courtroom looks like during oral argument. The sketch is 10 years old, so the lineup of the judges is not quite accurate. There have been a few changes in personnel in the last 10 years, but it gives you a flavor of what the place looks like. You can listen to oral arguments now. The audio is broadcast, but no video. Okay, so that's just to set the scene. Next, if you could pass this around, please. This is the outline of what I'm planning to talk about. As you'll see when you get the outline, there are a bunch of topics, 6 or 7. What I like to do is, if it's okay with you, is to cover each topic that's listed on the outline and then pause and give you all a chance to ask questions, make comments, and have some discussion. So if you could hold off on your questions until the end of each section, I think we'll make better, faster progress. So, section 1, how does a legal dispute turn into a Supreme Court opinion? And not everybody in the room is a lawyer, so if you will indulge me, I'll give you just a little bit of background of how our system works and how cases end up in the Supreme Court. Basically, we have two systems in the United States. We have the federal court system and the state court system. And state courts, there's a myriad of different courts, all kinds of levels. It's possible for a case to end up in the Supreme Court from either system, although it's a little easier to get to the Supreme Court from federal courts. But state people sometimes get to Supreme Court with state court cases. Generally speaking, the lowest level of federal courts are called district courts. These are the courts where the trials are held. In our system, we believe that everybody gets not only a chance to trial, but also if they happen not to be satisfied with the outcome of the trial, generally we guarantee everybody one appeal. But only one. After that, there are no guarantees. In the United States, we have 94 district courts. The country is divided into 94 districts. In Pennsylvania, we have 3 districts. The one we're sitting in is called the Eastern District of Pennsylvania for obvious reasons. The litigants who are dissatisfied with the outcome at the district court level get to go to what's called a United States Circuit Court of Appeals. And the country is divided into 13 circuits. In Pennsylvania, we're in the 3rd Circuit. The reason they're called circuits is because when the system was set up back in the 18th century, the judges actually rode from place to place to place. They followed the circuit to hear the appeals. The Third Circuit consists of Pennsylvania, New Jersey, and most importantly, the Virgin Islands. The reason I say that, it's not too important to me, but the judges, when they feel like having a nice paid vacation, can ask to be assigned to the Virgin Island District Court for a month or two, preferably, during the summertime. I once had a case in the Virgin Islands. I was very excited about it, but it never required my personal attendance. So I missed out on my paid trip to the Virgin Islands. Anyhow, on top of this pyramid, on top of the 13 circuit courts, is the Supreme Court, and we only have one of those. So that's how the system kind of works on the federal side. On the state side, there are millions of courts, and I don't want to get into too many details. Generally speaking, if you want to appeal from a state court proceeding to the Supreme Court, you have to work your way up all the way to the highest court in your state. In our state, in Pennsylvania, that's the Supreme Court of Pennsylvania. So after you get a decision in the Pennsylvania Supreme Court, if you're not happy with the outcome, you can attempt to go to the Supreme Court. An appeal to the Supreme Court, nobody has a right, or almost nobody has a right to get an appeal at the Supreme Court. In order to get there, you have to ask for permission. You have to ask the Supreme Court for permission to file your appeal in the Supreme Court. The thing that you have to file is called a petition for a writ of certiorari. And the Supreme Court is pretty stingy in granting certiorari, or as the lawyers like to call it, because they can't pronounce the word, cert. They're stingy in granting cert. And same, if you're trying to appeal from the state courts, you have to file a petition for a writ of certiorari. Now, everything I've told you so far is a gross simplification. It's much more complicated than that, but it's boring enough as it is, so I'll skip all the exceptions and curlicues. Instead, let me try to illustrate how the system works by an actual case. And I looked for a recent, interesting cert petition, preferably with a Jewish slant, and I found one. The name of the case is Elbaz versus United States. And let me just mention the fact that the name is listed first doesn't mean that Elbaz is suing the United States. Actually, just the opposite. When the case is in the Supreme Court, the name listed first is the name of the petitioner, the person asking for the appeal. And so really, the first name is the loser below, and Elbaz was the loser below. The person who filed the cert petition is Lee Elbaz. She's an Israeli citizen who is now 41 or 42 years old. At the time her legal odyssey began in 2017, she was the CEO of an Israeli binary options company called UCOM Communications. Just one illustrative detail about the kind of person Lee Elbaz is. In a recorded telephone call, she complained that while she had made millionaires of the owners of the companies she managed, she herself only earned about $500,000 during her 3 years overseeing the brands BigOption.com and BinaryBook.com. Quote, "I don't want to sound arrogant, that's not my thing, but I'm a fucking money-making machine."
Is that a quote?
That's a quote. She told a friend named Rami Regaim. It's a quote because some of her communications were captured on her phone and subsequently came into the possession of law enforcement, so we know exactly what she said, and that's one of the things that she said. Now, in fact, I don't think she was bragging. According to a press release from the US Department of Justice, and again I'm quoting, during her tenure, UConn was allegedly involved in swindling more than $100 million from investors around the globe through so-called binary option investments. These vehicles set a strike price for an asset, like an individual stock, and a deadline in the near future. If the asset is worth more than the strike price at the deadline, the purchasers of the option net a profit. If not, they forfeit their investment. The scheme involved the use of false advertisements to entice investors to deposit funds to purchase these binary options. Once customers had committed, UConn would then encourage them to deposit more money, and then they would refuse to let them withdraw the funds when they realized that this was not a really good investment. Some of the investors of the schemes were US suckers. As part of its retention efforts, UConn employees emailed 2 investors in Maryland and contacted a third by phone call. Ms. Albaz also had the poor judgment of choosing New York as a vacation destination. She was arrested by federal agents upon landing at JFK. She was charged with 3 counts of conspiracy to commit wire fraud related to the Maryland communications. Albaz sought unsuccessfully to have the charges dropped, arguing that the wire fraud statute does not apply extraterritorially, in other words, to conduct outside the United States. A jury ultimately found Albaz guilty on all 3 counts, and she was sentenced to 22 years in prison and ordered to pay $28 million in restitution. This happened in 2019, so she still has 18 years to go. She appealed her conviction in her case, it went to the United States Court of Appeals for the 4th Circuit, and the 4th Circuit upheld the conviction. Although it agreed with her that the wire fraud statute does not apply to foreign conduct, the Court of Appeals held that her conviction was nonetheless permissible domestic application of the wire fraud statute. The court reasoned that the focus of the wire fraud statute is the misuse of US wires rather than the creation and execution of a fraudulent scheme. So despite the foreign nature of both the scheme itself and Albaz's involvement in it, the 4th Circuit concluded that UConn's emails and phone calls to the 3 Maryland victims fell within reach of the federal prosecutors because they involved wires within the United States. There are many, many cases that say that telephones are wires, and nowadays internet is wires. So that's all covered by the wire fraud statute. And in a lot of these white collar cases, you will see the defendants accused of wire fraud. So that's how we got to where we are now. Albaz filed her petition for a writ of certiorari on April 27th, so 2 months ago. She's now waiting to see whether the Supreme Court will grant her petition. So the question for us this morning is, so what do you think are her chances of getting a hearing from the Supreme Court? That's a rhetorical question. We'll get to it in a second. But before you answer that question, let's go to the numbers, as they say. In 2022, there were 309,102 civil cases, not counting bankruptcies, filed in US district courts. In federal, there were 309,000 federal cases, not counting bankruptcies. there were also, these were civil cases, I should have said civil. There were also 71,111 criminal cases filed in federal court last year alone. So we're talking to close to 400,000 cases filed every year, civil and criminal. The Supreme Court has jurisdiction over both kinds. According to something I saw in state court in 2022, all told, there were 100 million cases filed, which is an astonishing number. That kind of means every household in America started one lawsuit.
Wow. In all the states, not just.
All the states combined. So some households probably do more than their quota, and obviously a lot of this is commercial litigation, and also criminal cases. They're also, they're counting things like traffic tickets and $200 small claims court cases. But it's a lot of cases. Your chances of getting from the lowest level, Pennsylvania, the absolute lowest level is called the magisterial court. That's what handles, those are the people who handle traffic tickets and $200 small claims. Chances of getting there to the Supreme Court are fairly slim. Now, so those are the numbers. Let's just, looking only at federal cases, 400,000 federal cases. Out of those, and it's not exactly, it's like the year before, but it's the same number. During this term, now the Supreme Court's term runs from October of, in this case, 2022 to October of 2023. So we're not quite done with the term, although the judges are kind of done working for the term because they're going on vacation next weekend. But the work of the court continues for 12 months. So far this term, they've had more than 5,000 cert petitions filed. And the clerks read all the cert petitions. The judges make the decision, but the clerks do all the reading, and they do a little, like, 1 page or less summary for the judges to make a decision. In order for a cert petition to become a case that the Supreme Court will hear, at least 4 out of the 9 judges have to agree that it's worth considering. And they do that based on the 1-paragraph summary that they get from their clerks, because they can't be reading. These petitions can be 100 pages long, not counting all the exhibits, which can be thousands of pages. So they couldn't possibly read all this stuff. Anyway, make a long story short, out of those probably 7,000 cert petitions for the 12 months, they select about 70 cases. That's how many cases they hear every year. So just on the federal side, from 400,000, they end up hearing 70 cases. And that's, the 70 covers both federal and state, all those cases, 70. And there are some cases that have a better chance of being among the lucky 70. You have appeals brought by the United States, by the US Justice Department. You have appeals by various state attorneys general. You have cases involving great constitutional issues, other things that are more important than somebody's individual case, although to the individual, nothing is more important. Elbaz, as she's sitting there, to her, that's her most important case. But my judgment, her chances of getting a hearing in the Supreme Court are somewhere between 1 in a million and zilch. But we'll find out. Probably by next October, we can check to see if her petition was granted. All right, that's the end of my first topic, so let me pause. And this is time for questions, comments, discussion. This, by the way, is a picture of Lee Albaz in better days, I've seen pictures of her as she was going into the courthouse. She doesn't look this good anymore, but anyway. Yes, sir. Sheldon,
I have a couple questions. One, you said that people have the right to appeal at least once.
correct.
Does the appeal have to be accepted?
No, when I say right, that means they get it, that nobody has to accept it.
So the
It's, they
court,
get an appeal.
so they can appeal and the court rejects the appeal?
Yeah, the court considers it and renders a decision.
And
The appellate court.
another question I have is about the fine. What if someone can't literally afford the fine? What happens?
Nothing. It's an uncollectible, it's a piece of paper, it's uncollectible.
And who determines how much they can afford?
Well, I mean, they can afford everything they got. So we have lawyers employed by the government, the federal government, whose job is to ferret out all the assets and seize them. I don't want to get off topic, but we have forfeiture provisions in both the federal statutes and state laws, where the government comes and grabs everything you got before there's any trial, before there's any legal proceeding whatsoever. Which is a problem because this happens to, hopefully, only to bad people like drug dealers. But that means they don't have any money to pay for their defense, because the government already grabbed all the money they had
Big problem for the attorneys.
to pay their own attorneys. Yeah, so then we have to pay the attorneys. We provide them with legal counsel because the Supreme Court has held that everybody's entitled to legal counsel, even people charged with misdemeanors. Yes, Ruth?
So I may have missed this, but so she was not the principal in the company, correct?
Correct.
They didn't go after the principals?
Well, that's an interesting
Or I'm
question.
just curious, not that it was.
It's a very good question to ask. There are like two guys, both of whom are Israelis, and as far as I know, they're still in Israel, and nothing has happened to them. I can't quite tell you why. Partly, Israel is reluctant to extradite citizens of Israel to other countries for criminal prosecution. But they do have an extradition treaty with the United States. This doesn't come up too often where Israeli citizens are extradited. So maybe that's part of the explanation. And maybe these guys have managed to make themselves scarce. There's one interesting tidbit, because before Elbaz came to New York, she sent an email to the guy who owns the company saying, you know, I'm planning to go to New York. Should I be nervous? And he said, no, yeah, I just got back. Go, she said, go. Yes, Rabbi.
So you said that everyone has a right of appeal, but doesn't one need to have grounds for appeal, such as error in law or error in the trial?
Yeah.
What if there's nothing you can complain about? Do you still get an appeal?
You get an appeal. There's always the risk that a court could sanction you for frivolous conduct. In the 100 million cases, there are at least 3 where somebody was sanctioned for frivolous conduct. We don't do that. And lawyers can ask the court to sanction the opposing party for frivolous conduct. When I was running a law firm, our rule was we never ask any court for sanctions, because next time we're gonna be on the other side and they're gonna ask for sanctions against us. So smart lawyers do not pursue sanctions against their adversaries. But it's theoretically, you could get sanctioned. Now what happens, and there are all kinds of courts. You can appeal from the magisterial court to the Court of Common Pleas. If it's frivolous, it's just gonna get dismissed very, very quickly. But you'll have had your appeal. Ruth?
How many clerks does each justice have?
At least 4. This is Supreme Court justice.
Right.
At least 4, the Chief Justice has more. And these are just, now, when we say law clerk, being a law clerk to a justice of the Supreme Court is kind of the pinnacle of what you can achieve as a recent law school graduate. These are the best law students from the best law schools in the country. These are smart people who are gonna live off of their fame as a former clerk to a Supreme Court justice for the rest of their careers.
And they have staffs as well.
They have a big staff, yes. So there's a lot of manpower or person power behind each of the 9 justices. Yes.
You said that the clerks will summarize the cases and give it to the Supreme Court justices. What if one of them or more make an error in their summary? Do the lawyers know what the summaries were?
Oh, no, you don't see any of these. These are all hidden from view, absolutely confidential. There's absolutely nothing the lawyers can do about it. I don't want to sell the justices short. The justices work very hard. We have all kinds of, nasty comments about these judges. These guys who are mostly, and gals, are mostly old people, work incredibly long hours. And they read a lot of this stuff, but I mean, 5,000 times at least 100 pages, that's 500,000 pages. Nobody's gonna read that. So they do need the summaries, but they sometimes go, if they have a question, if they don't like the summary, they go and check for themselves. They have fairly high standards for integrity in the Supreme Court. All of this, I'm sure, is shocking to you. But as a general proposition, these folks are straight shooters. They may have a little ideological bias. We all know that the judges themselves we all have biases, it's crazy to pretend that people don't. And so the law clerks who apply for a judgeship tend to apply to judges who kind of share their biases, and the judges tend to select law clerks. But I mean, if you're an ambitious young lawyer who just graduated from Harvard, you were the editor-in-chief of the Harvard Law Review, and you want to do great things in life, and you want to become a clerk of one of the justices, I can imagine that you're not going to advertise that, well, I'm actually a Republican and I know you were a democratically appointed justice. You're not going to, if you give me a job, I'll take it. Now, the other thing you should know is that the clerks don't generally get hired the day they graduate from law school. What they do is they get a job as a law clerk to one of the judges on one of the circuit courts of appeal. And they do a year or two as a clerk to a circuit court of appeals judge. And some of the circuit court of appeals judges have a reputation for picking good law clerks. And so some of these guys become like feeders for Supreme Court justices. So if you work for a certain guy then, or gal, I mean, you have to forgive me. I say guy, it means both men and women. That's a good way to have a good shot at becoming a law clerk to a justice of the Supreme Court. Let me move on because we have a lot to cover. Topic number 2, when does a parody become a Lanham Act violation? We start with something that's less than earth-shaking. This goes to show you that not every case is life and death. First of all, Lanham Act is a statute, a federal statute, and I'm sure Jack knows a lot about it because it has to do with intellectual property. Basically, it wants to protect people's trademarks, and most importantly, it wants to keep imposters from pretending to be somebody else. So just as an example, Coca-Cola, is a valuable trademark. Some people like to buy Coke. You don't want some other guy to come along and say and pretend that he's actually Coca-Cola and start selling you soda. Now, sometimes somebody comes along and starts selling Pepsi-Cola, and you have a very big case that goes to the Supreme Court on whether somebody is allowed to call his product Pepsi-Cola when Coca-Cola has a trademark. And that was a big case with that, in which Pepsi won. That cola, the word cola was deemed to be kind of generic. And so you can have Pepsi Cola or any other cola. Hold your questions. The main purpose of this whole thing is to prevent customers from being deceived into thinking they're getting the genuine article and they're getting a knockoff. That's kind of in a nutshell what the Lanham Act is about. So let's go to this case. So you can't pretend now, just to show you how nothing is clear in the law, that's how lawyers make a living. How many, we have a good group here for this. How many of you remember a great singer and composer called Weird Al Yankovic?
Oh, yeah.
Okay, that's what I thought. Well, now, here's a further test. How many of you remember a song that Weird Al came up with? This was very big in my house. It was called Eat It.
Yep.
Now, there was another singer who had a well-known singer, Michael Jackson, who had a big hit, probably sold 100 million records with a song called Beat It. And Weird Al came up with a song whose lyrics were "Eat It" and blah, 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 and the music was identical. So that's called a parody. And how did Weird Al, and he had another one, Michael Jackson had a song called Bad, and Weird Al had a song called Fat. And he parodied a lot of other well-known performers. How did Weird Al get away with it? And he could have argued that this is parody and therefore it's an exception to the Lanham Act. In fact, that's not what happened. Weird Al was so successful that he was able to go to people like Michael Jackson and say to them, give me permission to parody your song and I'll give you half the royalties that I make. And Weird Al sold millions of records. And so there was no litigation. I just thought it was kind of humorous, and you guys might have heard of this guy. But this was a real case. Just to illustrate what's going on. The name of this case is Rogers against Grimaldi. The Rogers in question, who brought the lawsuit, is Ginger Rogers. And Grimaldi is some Italian movie producer. There's an Italian film director you may have heard of, Federico Fellini. Federico Fellini made a movie called Ginger and Fred. That was the name of the movie. But it wasn't about Ginger Rogers and Fred Astaire. It was totally fictional, by the way. This was not a documentary. This was a movie like Fellini usually made, about two dancers called Pippo and Amelia. And the movie story was these guys were so good in their heyday in Italy that they were called the Ginger and Fred of Italy. And the movie takes place, 50 years later, they're old and they, it's kind of nostalgia. Look what happened to them 50 years down the road. The movie got mixed reviews and nobody saw it, certainly not in the United States. And Fred Astaire was dead by this time, but Ginger was still around, so she brought a lawsuit for, let's call it copyright infringement. And her claim was that Federico Fellini and Mr. Grimaldi and all these other folks who were supposedly hoping to make money off of this movie were falsely inducing people to go to the movie theaters by thinking that they were gonna see Ginger Rogers and Fred Astaire, when in fact they're gonna see Pippo and Amelia. So that was what the case was about. She brought the case in New York. It ended up in the Second Circuit Court of Appeals. There was a time when people said the Second Circuit Court of Appeals was the second most important court in the United States. Now there's contention as to which is the second most important court. But anyhow, this happened in the 1980s. The decision, the Second Circuit Court of Appeals heard the appeal and issued a decision in 1989. Because it was such an important court, the decision they issued became kind of the litmus test for when parodies are okay and when they are an infringement of the copyright or a violation of the Lanham Act.
Is it copyright or trademark?
It could be either one. It could be trademark. I don't think Ginger Rogers trademarked her name, for instance.
I thought trademark trademark is, this is coming from this producer, whereas copyright is, I wrote these words and you're reproducing these words.
If you'll indulge me, Rabbi, let me finish and
Okay.
and I'll come to
Because
your
I'm
question.
accused here.
The Rogers test. They decided, the Second Circuit, I don't know exactly where, I didn't go read their briefs, but they did read the briefs of the parties. But they decided that artistic works, which contain an expressive element, implicate First Amendment values. And, said the Second Circuit, John Newman was the judge. I argued cases before him. He was a very good judge, but he decided that these kinds of artistic works carry only a slight risk of confusing consumers as to the source of the content. And that was the test. And for decades, lower courts all used the Rogers test. So artistic stuff got a free pass. And there were other examples. Apparently, I don't remember this, but you guys might. There was a song named Barbie Girl that used the name Barbie. Now, Barbie was for sure trademarked, but that was okay. They got away with the Barbie Girl song because it implicates First Amendment law. It's an exception. On the other hand, there were other folks who, there's a case called Tommy Hilfiger licensing against Nature Labs, where somebody came up with, it says the word here is parodic. That must be the adjective for parody. Pet perfumes. And kind of making fun of Tommy Hilfiger's perfumes, and that did not trigger, they did not get away with it because there was more of a risk of confusion as to source identification. So that was the Rogers case. That kind of was the leading case. Now we come to a new case, and I have another handout. What did I do with my handouts? This was a long way to get to my second point on the outline. I don't know, I'm gonna stay on track here.
Can you just say when the Lanham Act, the year?
A long time ago. I don't know, Jack, 50s, 1950s, maybe earlier. It's been around for a long time.
That's the classic.
That's the federal law that kind of controls in this area. Okay, so you're looking at a picture here. A company named VIP Products is in the business of making squeaky, chewable dog toys. And they make their chewable dog toy look like different things. In this case, they made one that looks like a bottle of Jack Daniel's whiskey.
That's Spaniards.
And it's kind of, I think it's funny. Now, I'm gonna jump the gun a little bit. The justice who wrote the decision in this case is Justice Kagan. And she thought it was pretty funny. I'm gonna read a little bit from her decision here. It says, a bottle of Jack Daniel's Old No. 7 Tennessee Sour Mash Whiskey boasts a fair number of trademarks. Recall what the bottle looks like, or better yet, retrieve a bottle from wherever you keep your liquor. It's probably in there. So Jack Daniel's is a registered trademark, as is Old No. 7. So is the arched Jack Daniel's logo and the stylized label with filigree. That's the twirling white lines. Finally, what might be thought of as the platform for all those marks, the whiskey's distinctive square bottle is itself registered. Now, if you look on the right side, the name of the chew toy is Bad Spaniels. It is about the same size and shape as an ordinary bottle of Jack Daniel's. The full bottle, has the same black label with the stylized white text, the filigree border. The words Bad Spaniels replaces Jack Daniel's in like font and arch. Above the thing where it says the Old No. 7, the chew toy says the Old No. 2 on your Tennessee carpet. On the small print, I don't know, can you see it on the copy? Let me borrow one back. You may not be able to make it out, the copy since you're good. Where the Jack Daniel's says 40% alcohol by volume, open paren, 80 proof, close paren. This one says 43% poo by volume, 100% smelly. This is what they got.
This made it to the Supreme Court.
This is in the Supreme Court of the United States. Looking at my outline, this was argued March 22nd of this year. The decision came down June 8th, 20 days ago is the decision that we're talking about here. So this is one of our recent cases. Needless to say, Jack Daniel's sued VIP products. I'm sure VIP products tried to work a deal with them, like as Weird Al did, but apparently Jack Daniel's doesn't have a sense of humor, and they said no. Instead, they sued, and the case made its way to the Supreme Court. The decision in the Supreme Court was unanimous. Justice Kagan delivered the opinion of the unanimous court. Now, one thing you should know, even when they're unanimous, this should be familiar to us as Jews. Even when they're unanimous, they can't agree on the opinion. So she delivered the opinion of the court, but then in addition, Justice Sotomayor filed a concurring opinion in which Justice Alito and Justice Gorsuch, in which Alito joined, and then Gorsuch filed his own concurring opinion in which Thomas and Barrett joined. So there were three opinions in a unanimous case, which is, par for the course. Now, the funny thing is, this may surprise you, which is who won the case. Jack Daniels won the case.
Oh, really?
They said this infringed on Jack Daniels, and they were not allowed to sell the Chew Dog. This was not, in the opinion of the unanimous Supreme Court, artistic expression deserving First Amendment protection. This was just commercial competition, and these guys were trying to cash in on Jack Daniels' trademark, and so they are out of luck. They lost the case. Okay, now I'm gonna stop talking. Back to you, Rabbi. Remind me of your question.
Trademark and copyright.
Yes, I did make a distinction between those two. Again, it's a complicated topic, and I will defer to intellectual property experts like Jack to talk about it. There are, first of all, two kinds of trademarks. There are registered trademarks where you go to the trouble of going to the Patent and Copyright Office and registering your trademark. And then there are kind of common law trademarks. They're also, the same thing is true with copyright. Whenever you create anything, write down something. When you do one of your Friday emails, as soon as you put pen to paper, or as soon as you tap something on your keyboard, copyright attaches to your creation. You don't have to register it, but you can. You can register copyrights. You can file things with the Library of Congress, which helps you a little bit, but it's not required in order to secure a copyright. I'm not completely ignorant, I should tell you, because I am closely affiliated with somebody who owned registered copyrights and probably trademarks, registered trademarks, and probably does to this day. And somebody attempted to infringe on her registered trademark. And she brought a lawsuit represented by capable counsel. That would be me. And the case was settled for a lot of money. That was my one excursion into intellectual property. I didn't usually do that, but for this special client, I made an exception. So I know a little bit about trademarks, but not much. It's a specialty. Law firms, some do only that.
The distinction is trademark points at the source of the product, and copyright starts to the content of the product.
Correct.
Whether you can copy it or not.
Yeah, again, there are exceptions to copyright because there's such a thing as works created for hire. If you work as an employee of a company and your job is to write ads, let's say, you don't own the copyright to the ads you
They
write.
own the copyright.
Yeah, so actually, now that I think about it, maybe Bethel owns those emails.
So, in my contract, there is a copyright clause.
Okay, I didn't know that.
And it says that I own copyright on everything that I create, because God forbid, I don't want to become like these songwriters who get sued for making new music that sounds too much like their old music that someone else owns the copyright for. God forbid I give the same sermon twice. But, so I own the copyright, but the synagogue has free permission to use anything I create. while I'm here.
Interesting. Well, somebody actually thought about these issues before they did the contract. Yes, sir. Sandy, Sandy, we'll give her a turn, then you're next.
That's okay. Yeah, actually, the rabbi touched on the question I had. There was a recent decision where a songwriter, and I can't remember his name, he's very popular, wrote a piece of music, and there were, I think, 3 bars of the music that sounded just like another person. Ed Sheeran. And would that fall under this? Because he won, Ed Sheeran won. Yeah, because you can't hold someone that tightly to three rows of.
Well, the interesting thing about that case is that it got to trial.
Yeah.
That it didn't get dismissed on summary judgment motion. So apparently the judge who was assigned to that case thought it was a close enough question, so he left it up to a jury to make a decision. And it was a jury decision that it was not sufficiently similar, I guess. I'm not a big expert on this. I don't know why the judge felt it was a close, why there was not artistic expression protected by the Rogers test, but there you have it. And yes, there are, what really happens is sometimes people like Ed Sheeran sell 100 million copies of a record and they make $100 million. And somebody says, I'd like to have a piece of that. And when I say somebody, it's probably a lawyer who approaches the original creator and says, I'll represent you for a third of whatever we get. And that's how these cases come about. Sheldon.
I'm wondering about names of products that come into common usage, in particular things like refrigerator, which was a trade name, and Kleenex.
And
Xerox.
Xerox.
And Xerox, yeah.
And Yo-Yo.
Really?
Yo-Yo was a brand?
Yo-Yo is a brand. It is a centrifugal top.
Yes, that's a doctrine, and if you're an owner of a trademark, you have to zealously protect it. So the International Olympic Committee has a trademark on the word Olympics and Olympic, and probably every variation thereof. I remember a case, we were living in Rochester, some guy had the temerity to have a diner called Olympic Diner.
They were probably Greek.
He got a,
Right.
they were probably Greek. He got a letter, cease and desist letter, and then he didn't cease and desist. He got sued by the International Olympic Committee, and then he, we're talking a multi-billion-dollar outfit against a little diner, so he, changed the name. But yes, you have to zealously protect it. If you don't, you lose it.
But, I mean, refrigerator, what could they do about that? People call everybody's refrigerator.
Yeah.
And so I think they lost it. I don't know about Kleenex, but.
So Xerox was very successful. When the photocopier first came out, everyone called it the Xerox. Nobody says, I'm gonna Xerox something. They said, I'm gonna photocopy, because they were very good at defending their brand.
Again, there are people, lawyers
You're from
who
a
are
certain age.
painfully defending trademarks.
I say Xerox, he said, well, you're from a certain age.
All right, guys, let's press ahead. Next, this is a little more serious. Clean Waters Act. I'm going to talk about the case of Sackett against EPA. This actually has pretty far-reaching ramifications. The case was argued October 3rd of last year, but was not decided until May 25, so about a month ago. First of all, I just want to, I can't help myself. The name of the case is Sackett et Ux.
Yeah.
Wait,
So you may wonder what that is.
wait.
You see it in the et ux. Ux is short for like something. It's a Latin word. We had to learn it in law school. In Latin it means wife. But when we learned it in law school, to me it always sounded, and this dates back to the Magna Carta, to ancient, middle age England, when women really didn't count. They were an appendage of their husbands. They couldn't bring lawsuits. All the lawsuits back then were John Smith et Ux. And to me sounded like et Ox, which was like, an apt designation of the distaff half. This went out of usage like 200 years ago, except apparently in Idaho. This case, the Sackett case, originated in Idaho, and apparently in Idaho, they still talk about, in this case, something, Michael Sackett, and his wife's name is Chantel, but for purposes of this thing which will live in immortality forever, she's an Ux. Chantel does not have a name.
Uxor.
That's just that is just an aside that's got nothing to do with anything.
Could it be a woman's name, Ed Ux, and that's the guy, or it doesn't?
No, Ed Ux is wife.
Oh,
It's not a
wife.
husband.
It's not a spouse.
It's not spouse. There is a Latin word for spouse. There's a Latin word for husband, but Ed Ux is wife. Anyway, So, here are the facts. Michael and Chantel Sackett purchased a property near Priest Lake in Idaho, and which I've seen a picture. It's nice, you know, kind of looks. The lake is not right there, but it looks at a lake, and they decided it'd be a nice place to build their home. And so they began backfilling the lot with dirt to prepare for building a home. The EPA sent them a letter telling them that their property contained wetlands and that their backfilling violated the Clean Water Act, which prohibits discharging pollutants into the waters of the United States. The EPA ordered the Sacketts to restore the site, threatening penalties of over $40,000 per day. The EPA classified the wetlands on the Sacketts lot as waters of the United States because they were near a ditch that fed into a creek, which fed into Priest Lake, which is an intrastate lake, meaning within Idaho, but it's navigable. You can put a boat on it. The Sacketts sued, alleging that their property was not waters of the United States. The district court entered summary judgment for the EPA. They lost even without a trial. It was so obvious that they didn't have a leg to stand on. The Ninth Circuit, that's kind of the western states, California and Oregon, Washington and Idaho. The Ninth Circuit affirmed, holding that the Clean Water Act covers wetlands with an ecologically significant nexus to traditional navigable waters and that the Sacketts wetlands satisfied that standard. This ended up in a 15-year legal odyssey. After 15 years, this case got to the Supreme Court. In other words, the Sacketts filed a petition for certiorari from their loss in the Ninth Circuit. The Supreme Court accepted the case, heard the argument, issued a decision on May 25. And now let me just tell you, this may give away the outcome. The opinion of the court was delivered by Justice Alito. He was joined by Roberts, Thomas, Gorsuch, and Barrett. Thomas filed a concurring opinion, so he also agreed. In his opinion, Gorsuch and Kagan joined. Kagan also filed an opinion in which Sotomayor and Jackson joined. So as I'm reading this, there were like 6 different opinions. They unanimously held that the EPA was wrong.
Huh.
And the reason I say this is far-reaching is because the EPA is not the only agency of the US government that has taken upon itself to construe their mandates pretty broadly. This is an example of that. Now, in this particular case, and this got a lot of play, and this was, again, said to be just an example of the rightward tilt of the Supreme Court, but all 9 judges agreed that was overreach by the EPA. In this case, the court held that the waters, meaning the waters of the United States, to which the Clean Water Act refers to, only apply to, quote, geographical features that are described in ordinary parlance as streams, oceans, rivers, and lakes, and to adjacent wetlands that are indistinguishable from these bodies of water due to a continuous surface connection. Now, it's kind of common sense that that's probably what waters of the United States should mean, but it's a legal revolution in terms of the power of the federal agencies to construe their mandates broadly. So that is the Clean Waters Act case. Questions, comments?
Yeah,
Ruth?
their backyard, which was the wetlands, that didn't go into any other outlet from what you're saying.
It wasn't touching,
Yeah,
it wasn't
touching, it
continuous.
wasn't-
So it's just a marsh.
It was just a wetland that was self-contained.
And what the
It wasn't-
court says, a wetland is not really a navigable river, but if it's continuous, you can't tell where the river ends and the wetland starts, well, then, okay, we'll extend it to the wetland. But if there's a gap,
Right.
then it's not, the wetlands are not navigable rivers.
But if there had been open water, it would be a different story.
Yeah,
What is the Clean Waters Act?
well, it's the usual, we have a Clean Air Act, which actually came up, I didn't talk about it, came up this year in the Supreme Court also. The whole point is to protect, the environment. And we're all in favor of protecting the environment, which is worried a little bit about overreach sometimes by the federal government. So you're not allowed to pollute. In fact, if it's covered, you're not allowed to do anything. That's why if it's there are a lot of places that are wetlands. I'm amazed, we live, Regency at Yardley used to be a wetland. I'm amazed that they built anything there, how they got away with it. But apparently nobody sued them.
It's still not in the wetland. And there's certain restrictions to what you can do with the wetland.
Yeah. So, anyway, an interesting case that will have ramifications in future years. Okay, let me hurry along, and we're getting gradually more serious. The next one is when ideals clash with practical considerations. The name of the case is Jones v. Hendricks, who is a warden that tells you that Jones is a prisoner. Here's a sad tale of Marcus D'Angelo Jones. In year 2000, he was convicted on 2 counts of unlawful possession of a firearm by a felon and 1 count of making false statements to acquire a firearm. For this offense, he was sentenced to slightly more than 27 years in federal prison. Now, I suspect there might have been more to this. Sometimes, people commit bad acts, like kill other people, and it's very difficult to convict them. So the prosecutors choose something that's a little easier, like violation of the law that felons are not allowed to possess firearms. And then the judges sentence them severely because they know about the background. That kind of stuff comes out in what's called the sentencing report. So anyway, but we don't know that. I'm just speculating. He gets 27 plus years. He appealed to the 8th Circuit, and the 8th Circuit affirmed his conviction and his sentence. Then he had kind of what we call a collateral attack. He brought a motion, used to be called a habeas corpus motion, challenging his sentence, and he was partially successful. Although it was kind of a Pyrrhic victory, you could say. He got concurrent sentences for the 2 counts of firearms violation, each of which I guess was 27 plus years. And so on the habeas corpus motion, the court vacated one of the 2. So he's only serving 1 27 plus year sentence. The other one went away. Needless to say, he is still in jail. Now, just a little bit of background here on the habeas corpus, which is sometimes called the Great Writ. It traces its origins to the Magna Carta, which was signed in 1215. By the time the US Constitution was drafted in 1787, it was already an ancient writ. It was so well respected that it's explicitly mentioned in Article 1, Section 9 of the US Constitution, which provides, quote, "The privilege of the writ of habeas corpus shall not be suspended unless in case of rebellion or invasion, as the public safety may require it." So this is one of the very few things that the US Constitution specifically mentions and protects, and it's not even in the Bill of Rights, in the Constitution itself. And so prior to 1947, federal prisoners could challenge their convictions through a petition for a writ of habeas corpus. And they were supposed to do it in the judicial district where they were imprisoned. This was a problem because those districts that had big federal prisons in them, were inundated with these habeas corpus proceedings. So they changed the law and they changed the name. So it's no longer called a habeas corpus, it's called a motion to vacate, and you can bring it, or you have to bring it in the court that originally sentenced you, to spread out the caseload. And also the court where you got sentenced to begin with probably knows more about it, has all the records pertaining to your trial. So that's how it was starting in 1948. The one thing that changed is, as everybody else in society, prisoners became more litigious, and there were more and more of these habeas. People would bring more than one habeas proceeding, or more than one motion to vacate. They lost one, they would wait for a couple of years to try again. These guys have nothing to do. Some of them, spend their time in prison lifting weights. Others of them spend their time reading law books in prison libraries. A lot of these habeas things are drafted by the prisoners themselves. And they show up, handwritten, and the judge calls you up and says, Alex, do me a favor, I got a habeas, can you read it and, tell me what's going on? And you can't say no to a judge, so that's how these get handled. Anyway, that's how it continued until 1996. In 1996, one of the things that happened, I don't know if it was 96, but it says here, in the wake of the Oklahoma City bombing, people were pretty much in an uproar. So Congress, responding to the wishes of the voters, passed what they called the Anti-Terrorism and Effective Death Penalty Act, the AEDPA. And one of the things that it provided is that you can't keep bringing habeas corpus proceedings over and over and over again. You get one. So you get convicted, you get an appeal as of right, you get to try to go to the Supreme Court, you get all that done. After you're all done and you're still sitting in jail, you get to attack your conviction or your sentence through a habeas proceeding, but only once. And then you're done, and we don't want to hear from you again. That's what this AEDPA Act provided. So back to Mr. Jones. In 2019, with Mr. Jones still in prison, the Supreme Court held in a different case, the Rehave case, that in this kind of a crime, a felon possessing a unlawful firearm, an element of the crime, which people didn't realize was an element of the crime until the Supreme Court said so, was that the defendant had to know that it was illegal for him to possess a firearm. This is kind of, you can argue about that decision because we had this doctrine kind of in common parlance that ignorance of the law is no defense. But among lawyers, intent is a question, and how can you have intent if you don't have knowledge? So the Supreme Court said that in order to convict somebody, a felon, of possessing an illegal firearm, you had to prove that he knew that it was illegal for him to possess the firearm. So Mr. Jones, sitting in the prison library, reading the latest developments in the Supreme Court, says, wait a minute, in my case, when the judge charged the jury on what the law was, he did not charge them that they had to find that I knew it was illegal for me to possess a firearm. So I am an innocent man, he says. So he files what used to be called a habeas petition, saying, hey, let me out, I'm innocent. They didn't prove that I knew that it was illegal. He lost in the district court, he lost in the Court of Appeals, he got cert, and the Supreme Court decided to hear his case. And the case was argued November 1st of 2022, was decided June 22nd, that would be 6 days ago. So we're talking recent. This may not have been unanimous. Justice Thomas delivered the opinion of the court, in which Roberts, Alito, Gorsuch, Kavanaugh, and Barrett joined. Sotomayor, Kagan wrote dissenting opinion, and Jackson also wrote a dissenting opinion. So in this is the one case on today's agenda, I think, where you have this ideological lineup where everybody complains, 6 judges on one side, 3 judges on the other. Now notice, this is the first case where this has come up. Here is, and I thought I wrote down the dissent written by Justice Jackson, I think was 39 pages long, was significantly longer than the main opinion in the case. And, you know, she very well argued, but also quite vehement. I do have a little quote. She concluded her dissent with an observation, quote unquote, that the court's ruling, quote, follows a recent series of troubling EADPA interpretations that have now collectively managed to transform a statute that Congress designed to provide for a rational and orderly process of federal post-conviction judicial review into an aimless and chaotic exercise in futility. Throughout her dissent, Jackson repeatedly referenced the stakes of the decision for people like Jones who are serving time in prison, despite, according to her, being legally innocent of their crimes, a result she called, quote, stunning in a country where liberty is a constitutional guarantee and the courts are supposed to be dispensing justice, close quote. And so on. And she felt strongly. So here is a question for you people to consider. Who was right, the majority or the minority? And just to give the majority a shot here on this is what the SCOTUS blog had to say about it. As Justice Clarence Thomas put it in his majority opinion, quote, Congress has chosen finality over error connection. What's really going on in this case is, as I said in my thing, you know, ideals clashing with practical considerations, because the law changes from time to time, because the Supreme Court issues a new interpretation, or because the legislature or Congress amends a law. Now, sometimes it's such an important change that the Supreme Court explicitly says, we are going to apply this retroactively. And legislatures sometimes say it's going to apply retroactively. Most of the time, like 90+% of the time, they don't say that. They just say nothing. But obviously Jones says, well, if that's what the law didn't change, only the interpretation changed by the Supreme Court. So when I was convicted under that law, I should get the benefit of the new interpretation. The problem is that law changes all the time. And every time the law changes, you can't have every person convicted under the law come back and say, I want to get a new trial. Because you would, you know, I told you whatever, it was 70 some odd thousand cases per year in federal courts alone, criminal cases. Imagine if everybody had to be tried more than once. So Thomas said, we can't be doing that. But that means that somebody like Jones feels that, you know, this isn't fair what happened to me. So where do you come down on that?
Can I just ask something?
Yes,
So Jackson's comments, you said, was like, 39 pages, but it's one word, the one phrase that I'm, really questioning. When she said that he's innocent of the crime, it wasn't the crime, it was based on the knowledge.
Right.
But, right? So that it was just based on the knowledge of the weapon. It doesn't mean that he was innocent of the crime, right? I mean, she didn't specify that in her response.
You have to remember, every one of these people, every one of the justices is also a lawyer. They're all outstanding lawyers. They all graduated from either Harvard Law School or Yale Law School. They're good advocates. So, and they're also very good writers. So she phrases it in a way that is most persuasive of her point of view, which is why she calls him innocent, why the people who invested with Lee Elbaz are called victims. That's the tool of the trade for lawyers, is the language they use, and they use the language to be as
But it's
persuasive
vague.
as possible.
But
You know
it's persuasive, but it's vague.
Ruth, the law, correct me if I'm wrong, but the law says that it's illegal if you knowingly, so he said that he didn't, that he
Well, I'm
didn't.
not sure that it says knowingly. If it
So-
had said knowingly, then they would have charged the jury that you have to find that he did it knowingly.
Yeah, but wasn't that the whole premise of,
No, the
So-
Supreme Court read that into the
Oh,
law,
gotcha.
it's not in the law.
I see.
Yes, Rabbi.
I think what Justice Jackson is saying is, in order for someone to be guilty, they must be found five things have to be found true.
Right.
And his trial, only 4 things were found true. We don't know about the last one, therefore he's technically innocent. Because guilt only comes if you hit all the points.
All the measures.
That is certainly what she's saying. Yes, Sheldon.
It seems to me there's a real potential problem. One is, if he knew, he can say, well, I didn't know. But then, is it extended to what he should have known? And that's different than what he knew.
Yes, and that
So-
comes up sometimes. It's called the reasonable person standard versus the subjective person standard. Would the reasonable person have known? In some cases, that is what is required. Sometimes you have to prove subjective knowledge, which is hard to do.
But saying what a person should have known often depends on your educational background and your economic background. And sometimes, take a look at the laws helping people in poverty. Many people in poverty don't know they exist, but you'd think they should.
So Sheldon, that would require a new trial on that issue. And if the Supreme Court holds for, I can't believe I'm saying this, if they had held for Mr. Jones, every single conviction under that statute, under that charge, every single one would have to be retrialed for that other thing. And that's thousands and thousands of cases that automatically need to be retried. That's a nightmare.
And even more, here we're talking, the original trial was in 2000, this is 2023 now. So he still has 4 years left. You can't retry him because all the witnesses are gone. You can't find people, who were witnesses 23 years ago. It's, as a practical matter, you can't retry him. So that's, not only don't we have the resources to retry everybody, we can't successfully retry people because the evidence is gone.
But knowing that, Alex, wouldn't you think the Supreme Court would not have taken that case? Because, they knew that they would be opening up a can of worms if they,
That's interesting because it takes 4 votes. So in addition to 3 liberals, somebody else also.
Somebody else.
I don't know how many people, but at least 4 votes to grant cert. Let me move along because we are behind schedule. Really, Section 5 is 3 cases. These are cases that were decided June 8th, June 23rd, and June 27th. That's yesterday for those of you keeping score. These are all very recent cases. And I'm gonna briefly touch upon them, but the name of this section in my outline is Beware Facile Generalizations about the Supreme Court. And what I'm referring to is that we have all read a great deal about the ideological division of the court and the assumption that the votes of each justice are driven by their biases and entirely predictable. And so we need to do all these radical things. We need to pack the court. We need to term limit the judges. We need to remove some judges from the Supreme Court because this is intolerable. The thing that's interesting in each one of these 3 cases that has just come down is that in a single one did the justices align in accordance with this perception out there about how these guys are just automatons who vote, with whatever they're supposed to do based on who the president was who appointed them. So with that, I have very little time, so I'm going to briefly touch. The first case I guess I have here is the Texas case, I call it. United States et al. Against Texas. Here, the United States is listed first because they lost in the court below. This is an immigration case. We have a statute, federal law, in effect that, to summarize, says that people who have been convicted of certain serious crimes, and serious means not that serious, if the sentence is a year or more, and there's a long list of crimes. People who are in the country illegally, who are convicted of a serious crime, when they finish serving their sentence, are supposed to be handed over to the immigration guys and deported from the country. Similarly, people who are in the country illegally, who have had all their proceedings, they had their asylum hearings, their deportation hearings, they went through the entire process and lost, have exhausted all their legal remedies, are supposed to be handed over and deported. The Biden administration decided they're not going to enforce that law, period. The law is very specific. It says this is what you must do. The only exception is if the Attorney General certifies, I forget the exact language, but it's clearly written so that there are no exceptions. This is the law. And the federal government, the guy who is charged with faithfully executing the laws of the United States, is not executing this law. Texas and Louisiana bring a lawsuit that said this is imposing an economic burden on us. We have to deal with all of these illegal immigrants who shouldn't be here because they should have been deported under the law. So, judge, make them do it. Make them carry out their obligation under the law. The district court said, yes, you're right, Texas and Louisiana. The Circuit Court of Appeals said, yes, you're right, Texas and Louisiana. The Supreme Court grant cert. The Supreme Court says, you're wrong. Not quite. What they say is, you have no standing to bring the lawsuit. Standing is a legal concept. Standing means we want people who have an economic stake in the case, because the theory in our adversarial system, the way we decide cases, is you have two guys fighting with each other, each of whom has a vested interest in winning the case, so each of them is going to do the best they can to win. They're going to present all their arguments to the court, and so that way the court will have the benefit of all the work done by both sides in order to achieve a decision. If you have a case where one side couldn't care less, then the court does not have the best possible information. So one guy has no interest, that means the way we say it is that that party does not have standing. So the Supreme Court had that Texas and Louisiana had no vested interest, they had no standing. Those of you who know me know I feel very strongly about immigration, and I have very strong opinions, and I am an immigrant, and I'm not a hypocrite. And so I'm in favor of immigration. We should have more immigration. So this is not my personal view, but I think the idea that Texas and Louisiana had no standing is insupportable. Just a second, Chair. Here is the lineup. The decision of the court that said Texas and Louisiana did not have standing was delivered by Justice Kavanaugh, one of the worst people who ever lived. The opinion was joined by Justice Roberts, another one of the Rose Gallery, Sotomayor, Kagan, and Jackson. Gorsuch concurred in the result, although he filed his own opinion. It's sometimes hard to figure out who did what. Thomas and Barrett joined in Gorsuch's concurrence. So 1, 2, 3, 4, 5, 6, 7, I count 8 guys. There's one guy who dissented, Alito, was 8-1. It wasn't what you would have expected. Okay, I gotta rush along. Did you have a
I
quick
just had a
comment?
quick comment. I thought also involved in this case was the fact that the president had the right to prioritize which people were to be deported.
He's not prioritizing, he's not doing it.
No, but.
0 people have
But
gotten
he is by not doing it, he's prioritizing.
No, that's nonsense.
Aren't they still illegal? Aren't they still illegal immigrants when they get out of prison?
I mean, the problem is, sometimes we're talking about really bad people, like murderers.
Well, of course, but.
But anyway, I've heard this, that they're choosing just, anyway, I don't want to get into it. It's not prioritizing if you're not prosecuting anybody, or not holding or deporting anybody. Next case, Allen, who is the Alabama Secretary of State, against Milligan. This was decided on June 8th, 20 days ago. This is, and you've all heard a lot about this case. It's the Alabama redistricting case. It's a case under the Voting Rights Act. This is an issue that comes up all the time. It came up here in Pennsylvania. The parties have been known to gerrymander districts, and this is true of both parties. When the Democrats control the process, they gerrymander the districts to favor Democrats, and when the Republicans control the process, they gerrymander the districts to favor Republicans. And nobody pretends otherwise. I mean, it's not a secret. But here is the problem. We have the Voting Rights Act has a Section 2. And we have a 15th Amendment, and both of them say the same thing. And what they say is, quote, "The rights of citizens of the United States to vote shall not be denied or abridged on account of race, color, or previous condition of servitude." That's what the law says. You can't discriminate based on, just to simplify, based on race. But we come to this issue, and specifically as presented by this case in Alabama. I think in Alabama, they have 5 members of the House of Representatives, 5 congressional districts, based on the population of the state of Alabama. They have 1 minority-majority district, in other words, 1 district in which Black people are the majority of the voters. And that district has a Black representative in the House of Representatives. And they have 4 white guys, or white people, representing Alabama. The petitioners in this case brought a lawsuit saying that based on our population, we should have 2 Black representatives. And so the question is, does Section 2 mean that there has to be proportionality, as they call it, or equality of outcomes, as we call it in other contexts? What Alabama said is, no, all we have to do is be race neutral. And here is a map that we came up with, which is race neutral. It doesn't consider race one way or the other. We consider other things, like it has to be contiguous, the districts have to be contiguous, they have to make sense, like they're based on different counties or whatever, but it's got nothing to do with race. And so the question is, first of all, as a kind of ideological matter, do we want a system where we have to have things in proportion to everybody's share of the population? Which can become a problem when you have people who belong to 2 or 3 different minorities. So you can't, pretty soon you have to have like 150% of the population. But anyway, do we want equality of outcomes, or do we want what we used to call equal opportunity where we want race-blind setup. That was the issue before the court. And you probably know what the outcome is because it's gotten a lot of publicity. The Supreme Court decided that it has to be in proportion to the population. Now, the funny thing is, the Section 2 itself has in the legislative language, in the law, there is a sentence that says nothing in the Section 2 establishes a right to have members of a protected class elected on numbers equal to their proportion in the population. That's the quote of the language. But the Supreme Court went the other way anyway. Here is again the interesting thing here is, now this has political ramifications because this applies not only in Alabama, it applies in a number of other states. I've read articles that this kind of is going to move maybe 4 or 5 seats from Republicans to Democrats. But here's the interesting thing. The opinion of the court was delivered by Chief Justice Roberts. And he was joined by Sotomayor, Kagan, and Jackson, and Kavanaugh. Kavanaugh filed a concurring opinion in addition, and then there was a dissent. Thomas dissented, Gorsuch, Barrett, and Alito joined. So this was actually a 5-4 decision. But it didn't go the way you would have thought, since the evil guys control 6 of the 9 votes. How come the good guys won this 5-4? Okay, well, that was the case.
We're not political.
Yeah, they kind of look at who the good guys, the relatively good guys and relatively bad guys in some cases. And in this case, the relatively good guys switch sides.
All I'm trying to say, Harriet, in my inimitable fashion, is that all these generalizations that we all live in our information silos, and we all get biased reporting, and all of these simplifications about, this guy is never going to make a right decision, and this guy is always right. These are oversimplifications. They do not represent what actually happens on the Supreme Court and what happens in the real world. Okay, I have one more case. I'm over time. I hope you had a good lunch so you can hang with me for another few minutes. Is that okay?
Sure.
One more case I want to very briefly mention. That's the case that was decided yesterday, Moore against Harper, which again has to do with voting rights. This was a case from North Carolina. It kind of illustrates all the stuff that's good with our system and also all the stuff that's bad with our system. In North Carolina, in the election before last, so I guess that would be in the 2018 election, they managed to elect a Republican legislature. Very slightly, but Republican. And so they drew the map to favor the Republicans. The Democrats appealed. The Supreme Court, because apparently North Carolina is pretty purple, Democrats outnumbered Republicans on the Supreme Court of North Carolina 4-3. So the Supreme Court of North Carolina threw it out, saying you can't do that. This is too pro-Republican. That's not probably how they put it, but that was the net effect. So the Democrats, the losing side, appealed to the United States Supreme Court, and certiorari was granted. And there was a case, and it was decided yesterday. The interesting part is that there was another election in 2020. And in North Carolina, as in many other states, including Pennsylvania, they elect their Supreme Court judges. So in the 2020 election, 5 Republicans got elected to the Supreme Court of North Carolina and 2 Democrats. So the Republicans went back to the court and said, wait, you made a mistake when you say that the map was no good. They actually had a slightly different map. And so they said, come on, uphold this new map. And lo and behold, the 5 Republicans on the North Carolina Supreme Court said, yes, this is correct. The previous decision of this court, of the North Carolina Supreme Court, was incorrect. We overrule it, we throw it out, it's null and void, it means nothing. And now, this new map that you guys presented is fine. Meantime, while all this was going on, the previous decision is still sitting before the Supreme Court of the United States. Now, those of us who, were lawyers would think that that previous appeal was now moot, meaning it was no longer live because it had been superseded by a subsequent decision of the North Carolina Supreme Court. And if people didn't like the subsequent decision of the North Carolina Supreme Court, they could appeal from that one and go back and try to get certiorari, and then there'd be something for the Supreme Court to decide. But the previous thing was dead, so there's nothing left to decide. Much to everybody's surprise, the Supreme Court disagreed. Now, this stands in sharp contrast to where they threw out Texas and Louisiana. They said they have no standing. In this case, where it seems like this is a moot case, they decide, no, it's not moot, we're gonna make a decision on the merits. Now, on the merits, I don't know, I can tell you what's the merits, but I should probably stop. The director is saying I should stop. So I'll just tell you, the outcome again, on Moore against Harper, Roberts delivered the opinion of the court. He was joined by Sotomayor, Kagan, Kavanaugh, Barrett, and Jackson. Thomas dissented, and he was joined by Gorsuch and Alito. So it was 6-3, but it was 6-3 the other way. So that's just to illustrate my point here, that don't just assume how every one of these guys is gonna vote, because you can never tell. That's the end of my things. The last little quick thing I just wanted to mention, I was hoping to talk about 3 other cases. But unfortunately, the Supreme Court has not decided them. They'll probably decide them tomorrow. So next year, we have to schedule this 2 days later.
We can schedule it earlier.
What's your prediction?
I'm not, but I'll tell you what the 3 big cases that are left. Students for fair admission against Harvard College and University of North Carolina, that's the affirmative action case. Biden against Nebraska, does the president have unilateral authority to forgive student debt? And Creative against Elenis, that's the least important of the 3, which involves a Colorado woman, a web designer who claims to be a devout Christian and who says she cannot design websites for same-sex marriages or same-sex couples, even though she wants to sell wedding websites to the public. So can she do that or not? Those are the 3 cases that haven't been decided. You have to come back next year and we will discuss those 3 cases. So the last thing I want to tell you before you leave, or as they say in Congress, I'm going to yield the balance of my time, of which there is none, to the adult education co-chairs who have a couple announcements to make. Meantime, thank you very much for coming.
Big announcement, if you saw the email this morning, you know this already, but we have a new program coming up on August 23rd. There's going to be a sneak preview of the new movie Golda, about Golda Meir, starring Helen Mirren. The sneak preview is going to be at the Chamonix Theater, where Beth is buying a block of tickets. If you want to buy a ticket and see it with your friends, it'll be August 23rd, which is a Wednesday night at 7 p.m. Buy it on our website and get tickets, and you can all sit together, which will be a fun thing. After the movie, packaged in with that special sneak preview showing is going to be a recording of a Q&A with Helen Mirren and with the director about the making of this movie. So it should be an interesting program. Helen Mirren is playing Golda Meir, and Liv Schreiber is playing Henry Kissinger. And it's going to be about the Yom Kippur War and what led up to that and how it came in case you don't know, I don't wanna tell you the end.
I bought my ticket this week.
Oh, wonderful.
That's why I was late.
Our first person here, thank you.
Really?
It only came out this morning, we already got permission to do the purchase of the tickets last night. So, I mean, you are like right on the spot. Besides that, also coming up this year on July 16th, we're having, which is a Sunday afternoon at 2 p.m., we're having a walk on the Princeton campus. We're gonna be joining a public tour of sculptures on the Princeton campus. Should be a fun day, and if you're interested, please join us there. You'll see information about that on the website. And finally, starting August 30th, and then again on September 6th, we're going to be transitioning through Elul from the lightheartedness of summer into thinking about more serious spiritual matters. And so we have some programming there that is going to be that combination of lighthearted plus a little bit more serious thought. And that's going to be Rabbi talking about The Good Place. We're going to be right there in the chapel. We're going to be showing an episode of The Good Place each week, which is a funny show and fun and laugh together. A very short minion, and then we'll have a discussion of the more serious theology and moral philosophy behind the show that we just saw. So 2 episodes, and should be a fun time.
Just a quick addition, the tour of the Princeton campus will be conducted by a docent of the Princeton Art Museum.
Yes.
So she will explain to us what we will be. They have some very good sculptures.
Yeah, it's really quite an amazing place. Okay, you're released, but there's lots more food, so,
Yes.
please.
Time
feel
for a
free.
second lunch.
Time to graze.
Thank you.
You're very welcome.
I finished the book that I suggested,
Yeah,
and I suggested a little more strongly.
very interesting. Okay, I mean, it's up there on the list, so we'll absolutely do that.
There's an extensive description of death camps.
I don't have process.
Well, everybody should find it trouble. Some people
Well, I did this.
Tell people it's sort of a trigger warning kind of a thing.
I mean, they do an excellent job. The decisions you can read.
But I mean, I don't think it's proper attention.
And, with the choir, everything we sing is copyrighted. Except for like a problem of melodies, but then some of the arrangers are 21st century.
I got it.
So we are very, very,
Charge for the Princeton
That can only become great, because writing is with R-I-G-H-T.
I've done it, but I haven't done all of it.
Thank you. That little poem of whatever. But we are. I mean, in fact, I usually when we have a concert, I